Hi, folks. We had a little bit of technical troubles this morning, just getting it started here, but I'm going to have Erik Strickland join us because he's going to help me with hosting this. And then once he's in and we're ready, then we'll start here. So give us just one more minute here. All right. Okay, I think we have everything kind of set up here now. Apologize for the delay in getting everything running, but I think we are set. So, with that in mind, welcome everybody. Thank you for joining us um, here over the lunch hour just to briefly talk about um, estate planning and that in particular with regards to those of you that have special needs kids. So, let me double check the screen share here and make sure that it is working the way we'd like it to. That to go full screen present mode here. All right. Okay. All right. Um, so first things first, my name is Erik Wasson. I'm an associate attorney here. I'm also going to invite Erik Strickland to help present this with me. He is a recent law school graduate. Um, he is really quite an awesome person to work with. He also kind of has an estate planning background. And I'll let him introduce himself here quick. So I'll go ahead and let him unmute and just Erik, if you don't mind, kind of introducing yourself to these people.
Hello, can you hear me?
Yeah, we can.
Okay, perfect. Hi, everybody. My name's Erik Strickland. Yeah, like Eric said, I'm a recent graduate from UNL College of Law. This summer, I'm just working on studying for the bar exam. Um, I also have a little bit of an estate planning background. That was a concentration of mine in law school, and I am very happy and fortunate to be able to help out here to explain some stuff to everybody today.
Awesome. All right. Thank you, Erik. Um, so yeah, I will go ahead and start. And my goal is to keep this conversational. So if you have questions, if you have something you want to share, if you have any ideas, experiences, whatever, please feel free to jump in at any time and engage with us. However it strikes you. Um, this is really a collaborative environment, and it's meant more to be a shared experience for all of us. So please don't feel, please don't feel like you have any, you know, issue at all jumping in at any point. Um, so this presentation, we named it Mind the Gaps. And what that's really referencing is some of these estate planning errors that we see really often, even from really experienced, really seasoned, well respected attorneys. You know, Oftentimes what can be a really great normal estate plan might end up causing some issues if you're a parent of a special needs kid. And so we want to kind of identify those, address them, invite all of you guys. If you don't have estate planning, let's kind of take this as an opportunity to consider start doing some planning. And while we would love to have you work with us because our firm is really specialized in guardianship, conservatorship, and then the special needs planning that goes with that. Um, but even just in general, let's start thinking about estate planning. And if you have planning in place, great. Maybe you'll see some of these errors in your plan. So I don't know, some of you might have brought along your will, your trust document, stuff like that. Um, it'd be great to start looking through that and seeing, okay, maybe some of these errors are something that I've encountered. So, or that's something that you identify in your plan. So we'll start here. Um, One of the really big issues that we see happen sometimes is people hear about something called Enable. And Enable is an awesome program. It is a way that folks can be able to put some money away and save it. And, especially this is for people who are on benefits, government benefits, who may have special needs or some kind of disability. Um, And the real issue that happens if you are on government benefits is that if you're earning any kind of money, whether it's Social Security or you're working a job, even as part-time, you might run into income limits. And um, the problem there is that's a pretty short cap. So it's a $2,000 basically cap on savings. If you exceed that, then the government's going to say, whoa, 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 you have too much money. We can't keep giving you government benefits, which sounds silly, but that's kind of how they operate. And so Enable was created a number of years ago as a way to help people save money in a bank account type system. Enable is the Nebraska version of an Able account. And so people say, oh, Enable, great. That's a great option. And we totally agree. It's a great option. What we do not recommend, though, is for people who already have a special needs trust set up. Like, for example, if you as the parent have a special needs trust set up for your child, do not ever, ever, ever go ahead and terminate that and then only put that money into Enable. And you say, well, what's the difference? They're both sort of a bank account for my kid. Um, Big difference. One being, if you have a special needs trust set up already and you go ahead and terminate that, what's going to happen is all of that money that was your money is now that person's money. Um, and the big issue there can be, let's say that your child does pass away at some point in the future. Now, let's say there's money left in that Enable account, or um, or just money left over at the end. Um, while Enable themselves will tell you that they will just send a check to the estate, that's very well and good. The estate will still have its own issue because Medicaid recovery does not distinguish between people with disabilities and not. They just ask for you to fill out the form if you were receiving Medicaid or were over 65 when you passed away. And so when you fill out that form and you submit it, they're going to say, whoa, 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 you're subject to Medicaid recapture. So all of that money that's left over in that Enable account could be subject to Medicaid recapture. Again, Enable oftentimes will say that that's not how it should work or will work. I hope that that's true. But I do know that Medicaid recapture, they don't ask you that necessarily. You just fill out the form with your identification, et cetera. And then they let you know whether or not you're subject to it. So it's a pretty big risk. And the difference being too, if it's your money as a parent and you have that money in a special needs trust, or it's going to go into a special needs trust when you pass away, then it's a really nice thing, because not only does it provide for all of those kids' needs, during their life, for all those expenses that are kind of beyond what government benefits will cover, but then also you can designate beneficiaries for it afterwards. And so when your child does pass away sometime, it could go to your siblings, it could go to your other children, it could go to extended family, it could go to charities. It could, there is an unlimited amount of places that you could allocate that money afterwards rather than it going to the state. Um, and so that's really the big issue there. The other issue too is, let's say you had a special needs trust set up. You go ahead and say, we're going to terminate that. We're going to put all the money into Enable. Okay. What if there's too much money in that special needs trust? And now you've exceeded the amount of money that Enable will even let you contribute in a year. That could be a really poor situation, because now that money has to go to their individual bank account, and now they've exceeded income limits for benefits. And so now they're losing benefit eligibility for SSI or Medicaid or Section 8 housing or whatever benefits they're receiving, right? So it's something that you really, really have to be careful about. And if you have that trust set up already, there's really no benefit to just ending it willy-nilly. And we always tell people too, you can use both pieces. There's a time and a place to use both the special needs trust and Enable both. Use the special needs trust for your money. Put the money that you want them to be able to access in there, that's your money. Enable, put their money in there. And that way it still can be used for their needs. You can use the Enable funds first. And then if those get completely, exhausted, then they could tap into the special needs trust funds. But, don't burn that bridge first, right? I think that's really the big pieces here that I wanted to hit about just the special needs trust and Enable, and kind of that how they work together if they're done right. I guess one last thing too is, if you do terminate that special needs trust, you do lose some oversight. You lose some professional oversight. You think about the role of a trustee. They have fiduciary duties. And if it's a professional who's managing it, like Um, for example, Nebraska Guardianship Council, or even a corporate trustee, they'll probably understand those benefit rules and kind of the appropriate disbursement time and place, right? Um, Enable is like a bank account, and so they don't have those same um, levels of oversight to them necessarily. Obviously, they have oversight built into it by being like a bank, um, but it's a little bit different than having a trustee where you have that real one-on-one individual relationship um, with the trustee. So I will move on to slide 2 here, and I'm going to invite Erik Strickland here to kind of talk about trustee selection.
Hi. Um, yeah, I'm talking a little bit about second mistake that and
Hey, Erik, I think your audio has been a little wonky. If you don't mind, just mute and unmute for us and see if that fixes it.
is that better?
It is.
Okay, perfect. All right. So I'm going to talk a little bit about the second issue we want to discuss today that can happen as kind of a common special needs estate mistake. That's picking the wrong trustee. Um, Obviously, when dealing with any trust situation, it can be a pretty complicated document. And in general, you want somebody who is the trustee to be able to handle financials. You want them to be competent and comfortable in dealing with a lot of these more complicated financial situations. Now, when picking a trustee, um, I think there's sometimes can be a lot of pressure to pick somebody who might be a little more corporate, for example, a bank. There's a lot of banks that offer trustee services. But in a special needs trust situation, a lot of these banks may not have the capabilities that some of these other institutions, like, for example, Nebraska Guardianship Council, might have the ability to help with. So I'm just going to go through a couple reasons why picking something like a bank, while not always uh, essentially maybe the wrong decision, can be problematic depending on the circumstances. For example, a bank compared to something like the Nebraska Guardianship Council, which for those who don't know, um, is a small group of individuals who are very specialized at dealing with specifically special needs estate plans and other different types of estate plans. Banks have uh, potential for lack of flexibility or personal understanding, often operate by rigid policies and insight life or needs. Trusts can be restricted. So to get out of those trusts, something like a bank may be cautious.
Erik, I don't know
Beneficial.
if it's just me, but I think I'm losing the audio again a little bit.
Well, let's see. Is it any better? Is it any better?
Yeah, I think so. I think so. I'm
Okay.
gonna butt in real quick too, if it's all right. So I had a comment from Anne. So enable accounts say less than $5,000 can be paid to the account holder beneficiary, and there's a form for that for the small estate affidavit. So yeah, that's a good point. If you have a small enough amount in that enable account, totally not a problem, because you can do that small estate affidavit form. Just if you exceed that $5,000, that you at least run into the possibility of having issues, right? So thank you, Anne, for bringing that up. Erik, I'll let you continue.
All right. Sounds good. Is the audio doing okay?
On my end, it sounds good. So yeah.
All right. Perfect. All right. So I'm just going to go back to a little bit what I was talking about regarding overcaution. So banks in general can obviously, due to their corporate structure, be a little more overcautious when it comes to taking money out of trusts. Now, for sometimes beneficial but unconventional requests, for example, a day at the lake or something that a beneficiary could benefit from. That this is something that person normally does in their daily routine, but a bank might say, well, we're not used to this. We're not going to let you take money out for this. A place like NGC, where you have specifically more people who are personalized, they know you, they're familiar with your situation, they will be more comfortable and competent in being willing to make those exceptional circumstances work. Also, when you have a place like a bank, you might have to deal with high fees. Banks and trust companies can typically charge management fees based on a percentage. These may be disproportionately high, especially for small or moderate size trusts, and that can be a regular trust or a special needs trust. The big thing I want to go back to one more time is just limited experience with special needs law. Not all banks are going to be experienced with complex SSI, Medicaid, or benefit rules, um, like firms like NGC and others that are familiar with those. And mismanagement can cause beneficiaries to lose eligibility for critical benefits, especially if they make improper decisions. Also, banks might just have slower response times. Again, it all comes down to the personalization that a lot of these smaller, more competent, comfortable firms who know this material are going to need to be a lot better with in terms of picking the right trustee. In general, that's all I would have for this slide. Anything you'd like to add, Eric?
No, I guess the only thing, and maybe I just missed this during some of um, the audio issues I was having. But one of the things too to always consider is a lot of banks and trustee companies and stuff like that will have kind of these minimum asset requirements, and oftentimes that's a pretty high number. Oftentimes, sometimes $500,000 or more. Um, and to their credit, there are banks and trust divisions that um, are willing to modify, and accept lower amounts in particular circumstances, but not by default, right? So, um, that's just not a situation that probably most people are going to fall under. So, you know, I think it's good to just remember that, it just might not be a sort of default option like we like to assume it could be. So, um, yeah, I think next thing we were going to talk about is overfunding, and Eric, I think you're going to start us off on that.
Yeah, absolutely. Um, yeah, first, Eric, yeah, I totally agree. No, absolutely, banks can be the right decision at times. It's just in this circumstance, probably not the default. Um, so yeah, if you can pick the right trustee, obviously next up you want to make sure your trust is funded. But obviously, sometimes you can have issues with overfunding, especially in a special needs trust. You would think, oh, what's the issue with being maybe a little too generous, putting quite a bit of money in there for your beneficiary? What's the problem with that? Well, in these situations, having a little bit too much money in there can actually be quite a problem. Um, First off, that money can be unusable for any other person during the child's life. Also, some potential risks. You could have a waste of assets if the beneficiary dies and there's a first party special needs trust. Medicaid has right to be repaid, and that can cause some issues as well. Also, in general, there might be some tax inefficiencies. Special needs trusts can often be taxed pretty highly. So if you overfund them, put a little too much in there, you could have high tax burdens, especially if the trust earns a substantial income. Also, inaccessible funds that have restrictions on them, which can be a pretty big issue, especially if the trust is over.
Yeah. So I'm gonna add on to all of that. That's all totally, correct and useful. Um, you know, One of the risks with overfunding, and people sometimes will hear us say, "Don't overfund the trust," and say, "What do you mean? This is, you know, I have 3 children, 4 children. Why shouldn't I just give each child? Let's say I'm doing well in life. I have $1 million ready for all of my children when I pass away. Okay, if I give each child 250K, or maybe I'm worried about this, my special needs child, I want to give them 500K, and I want to, split the amount among my other children. Practically, while the intent is totally like well intentioned, it's a great intent. Practically, what that can do though is you're tying up money for the duration of somebody's life, who really won't have the ability to use it necessarily. Now, I do caveat that because there may be times and situations where a person has particularly high needs, that won't be covered by Medicaid. Um, That's pretty unusual, though. I mean, typically, if you're going to be under Medicaid, you're going to still be receiving the bulk of the expenses paid. And then obviously, you can tap into special needs trusts to cover excess or additional care beyond that. So if you had, um, an optional surgery or something, then you could tap into funds for that. Um, but again, the bulk of the money, the bulk of medical expenses at least, or stuff like that is going to be covered by Medicaid. So yeah, there's only so many chairs, you can buy so many pieces of clothing, so many video games or laptops or all of that kind of entertainment discretionary quality of life items. There's only so much that you can buy, and oftentimes I have clients that will come to us and say, heck, my child, she won't even buy anything if I don't tell her she should, right? And so there's a real risk that you're tying up the money um, in a way that it's just not going to be able to be used for quite a bit of time. And quite frankly, some of this is um, advice that probably has changed over time, partly because of technology and medicine improving over time, where, we think about Down syndrome in particular, the life expectancy for somebody with Down syndrome has gone up tremendously. And that's awesome. That is awesome news. Um, what that also means then is maybe people in the past were less concerned about, having a big chunk of money tied up for a shorter period of time. Whereas now I think, you have to remember that this person's going to live quite a long time, right? So um, you just don't want to tie up money where it's going to be unusable for your other family members or a spouse or anyone else. Um, you know, Eric had a really good point too about Medicaid clawback. So when we talk about Medicaid clawback, we talk about two types of special needs trusts. And I don't even need to get to the full distinction there, but basically, if it's a third party special needs trust, meaning it's your money, that Medicaid clawback doesn't apply. But if it's their money or it becomes their money due to not doing that estate planning, due to not having the special needs trust set up beforehand, then all that money that's sitting in the trust when they pass away, up to the amount that needs to be reimbursed will get clawed back. But for most people, that's basically the whole amount of funds. So you're looking at, $100,000 or more maybe that could have gone to other people in the family that's now going to the state. And for most people, that's not their goal in their estate planning, right? They don't want to give their money to the state. That's the whole point is that we get to avoid that. So it really matters if you set these things up beforehand or whether it has to be set up after the fact. And when you get into a situation where it has to be set up after the fact and it's a whole lot of money, that's a really bad feeling knowing that if it doesn't get used, then the state's going to claim it back. Oh, I'm sorry, guys. Ripped through the slides here on accident. Okay. I think that was kind of the last piece here on overfunding. And we can move on to basically the opposite side of this, not funding it. I guess before I do, one last thing. So our just internal recommendation, we recommend kind of capping your contribution at about 100K. Um, that actually kind of mirrors to what Enable will allow you to hold as kind of a maximum anyways for the Enable accounts. But I think it really kind of lines up well just in general. You can try to kind of pace out and figure out what somebody's needs above Medicaid are going to look like year to year. But usually, an amount that's at 100K or somewhere less than that will be plenty for somebody's needs throughout their life. So obviously, that's subject to change. People may have specific situations where it's not going to be enough, but that's kind of our recommendation. Christy had a quick question here about, can you create a shared special needs trust in Nebraska? Christy, I'm guessing you're talking about pooled special needs trusts. And yes, that is the thing in Nebraska. So, that's one way. If you don't want the money, if it's a first party trust, meaning it's that person's, the special need kid's money, and you're worried about that Medicaid reclaim reclaiming the amount left when they pass away. That's one way that you can avoid that. Now, what it doesn't do is it doesn't mean that your particular beneficiaries are going to inherit that money. But if you used a specific pool trust, which we have like one in Nebraska that's specifically named by statute, or by regulation, if you use them, then the money would go back into the pooled trust for other people to use. So it would go to the benefit of these other people who also have special needs, um, but it wouldn't go to other family members, right? So better than going to the state for probably what most people would say, right? But still maybe not as ideal as just doing the special needs trust planning up front, to ensure that, it can go to other family members if that's your desire. I think that's what you're talking about, Christy, but if you're thinking of something else, please let us know. I apologize, my throat's getting scratchy here, so I'm gonna get some water. All right. So the fourth big issue we see is not funding trusts, whether that's your actual trust as husband and wife individually, and that trust probably has, some kind of language like we do, where we have a built-in sub-trust in it, so that when you pass away, if one of your children is going to be on government benefits, out of that trust springs the special needs trust for their benefit. Still a third-party one, but just within your document. Or maybe you have a separate document, kind of a standalone special needs trust. That's also something that we do all the time. A lot of attorneys, most good attorneys are going to give you some instruction about funding your special needs trust, funding your own trust. Now, what happens oftentimes and can cause a lot of issues is you might get those instructions and then you sit on it and you forget to actually follow through with those instructions. And so you never change beneficiary designations, you never title properties into your trust, you never go through the list of your bank accounts and add the trust as a beneficiary, or you know even just talk through with your attorney, okay, I want this account to go here, I want this account to um, go here, or how should I handle these different accounts, right? uh, if you don't follow through with that, that can have some really bad consequences, because what that practically means is where your trust, most people say, okay, I want to trust because I want to avoid probate. That's great. Trusts do avoid probate. Um, and that's a really big issue for us in guardianship conservatorship world, because the difference between that and probate estate, where everything just goes as if you didn't have a will, or goes intestate, um, that could be a really big issue, because all of that money that you wanted to give to your child in a third party special needs trust, that money is now theirs. And all that stuff we talked about earlier about benefit eligibility, that's going to kick in. And so now that person's going to have to either create a first party special needs trust, or they're going to have to try to run to enable and say, hey, hopefully I have less than the contribution amount this year, the $19,000 that I can contribute. If not, if I have too much, then now I have to do a special needs trust, a first party, and now that money is going to get clawed back by Medicaid. So it's a huge difference between if you fund your trust or make sure that your trust will be funded when you pass, versus if you don't take those steps. We talked about the loss of benefits. That's really the biggest issue and risk. Practically, too, you think about it, if you don't fund your trust, or the special needs trust isn't going to get some kind of funding, then it's really just an empty shell. It's there existing in name. You probably paid some money to set it up, and you have a legally valid document. But now there's nothing going on into it. And so all of these specifications you might have talked through with your attorney, and all sort of the default provisions that good trusts will have, if you don't have a plan that where your will says, okay, those trust provisions should be now treated as if it's my will, then all of that gets lost. And so you might have had some really particular, unique things in your trust about, I don't want my child to receive a certain amount until they're 25, and then 30, and then 35. Or that would be for a child who's probably not special needs, right? Um, or maybe you had special things, about if my child is incarcerated, then I don't want that share to go to them. Or, there's things that you can put in your trust that are really unique, and that's one of the powers of trust is that you're able to create, unique situations, flexibility, et cetera, that just really isn't common or um, really possible in a will in the same way. But you lose all of that. You lose all of those creative pieces that you had done and all of those kind of boilerplate spendthrift provisions and stuff like that. Um, you just lose it to the wind. And so that's a really frustrating thing, I think, for people who just don't realize that's what can happen. And quite frankly, too, practically what can happen is you just end up with a lot of confusion among family members, and you end up kind of ripe for a legal dispute. You end up setting up a situation where somebody expected that they were going to be inheriting under a trust, maybe because the trust had said so, and you have this unfunded trust, nothing goes into it, and now they say, well, hold on, I was supposed to receive $100,000, or maybe you named a charity even in your trust. That could be really setting yourself up for um, some legal trouble because, kind of the default rules on this are if you have a charity named and you make a promise to a charity of a gift, that's a binding contract. And so, I would not be shocked if they were to say, well, especially if it was a large estate and you were, promising them $1 million. If the estate isn't itself going to be willing to follow through on that promise, they would totally have the right to sue on that. And so you're kind of opening yourself up to the risk of litigation if you're not ensuring that your trust is actually going to be funded. Um, and partly too, it's about control of these assets. So trusts are handled by trustees, right? The trustee gets to read the trust document and see what it says about when distribution should happen, and then they make those distributions. If you don't have a trustee, um, or you have a trustee, but there's no assets to actually manage because nothing got set up right, then the risk is, okay, now I have to go and talk to the personal representative potentially of the estate. And maybe we don't get along. Maybe we're different people and we don't like each other. And now we're fighting about, who's going to control funds. And so it's just a real opportunity. If you don't take care of it from the get-go, um, you can really set it up for just kind of chaos on the back end. So it's just one of those things that if you deal it right, um, you're gonna enjoy the benefits of having everything smooth and streamlined. If you don't, make sure that those, I's are dotted and your T's are crossed. You could be opening up to a world of chaos. And the other thing too, just practically, is you miss some of that tax and um, particularity of planning, those opportunities. So, we talk a lot about during how we fund things, right? So, and what assets do we want to put into a trust versus not? Um, so, there's things that we recommend putting in a trust. It's totally okay and right to put a home in a trust or to put a Roth IRA into a trust. But what can happen if you put the wrong kind of things into a trust? Let's say you put in your 401k, you put in a vehicle. Both of those are really problematic for different reasons. The 401k is problematic for something that Erik Strickland alluded to earlier, which is income tax. Because a 401k or just a normal traditional IRA is an account where you don't pay the tax on it now when you contribute, but then you do pay the tax on it when you retire. What happens is you have a whole bunch of income that's coming in, and it's all subject to income tax. And you say, okay, whatever, I don't make that much money. It's not a problem. Well, okay, it wouldn't be normally, except trusts, all trusts, the dollar amount that you are allowed to get to in income for each tax bracket is essentially scrunched down. So maybe I don't even know off the top of my head, but the lowest tax bracket, maybe let's say it was up to 25,000. Under a trust, it's going to be much, much lower, maybe 2,000 or $3,000 of income. So if you have mandatory required distributions because you have a 401k that says, hey, once you turn 65, you have to start making withdrawal amounts of X percentage of those funds. And that percentage is going to go up every single year of your life. Then all of a sudden you have a whole bunch of income coming in that's going to be taxed at much higher rates. And so you could be paying much more in income tax than you would if it wasn't going to be in your trust. And so that's just an important thing to remember is, um, there's a time and a place to put retirement accounts in a trust. And there might be reasons for it, regardless of income tax stuff. But typically, when we're talking about qualified accounts, those those monies that have not yet been taxed, it's a pretty bad idea. And for a different reason, we also talk about like vehicles, for example. So if let's say you have a nice luxury Lexus SUV, it's a $70,000 SUV, maybe, let's say. Awesome. I'm happy for you. Maybe a little jealous, but I'm happy for you. And you put it in your trust. Well, okay. Now let's say you get in a really bad car accident. Um, Conventional kind of lawyer wisdom would say, if I'm the person who's going to sue you and say, hey, you injured this driver really badly, they're going to have a lifetime of needs. That whole trust could be now available to tap into. And it's no longer just the vehicle or, um, something like you're just opening it up to everything, right? And so there's some risk there. And that could happen even if, let's say, you put the vehicle in there um, and it's jointly owned. And maybe you individually have a trust, but you jointly own it with your kid. And now your kid gets in a car accident, right? So you're really opening up a whole bunch of doors that you don't necessarily need to, just because you wanted to have the trust and you were doing your very best to make sure that you're funding it, you're putting assets into it. Um, you put the wrong things in, and now you're also kind of creating some risks. And so what we pride ourselves on is we kind of facilitate front to back. So we will talk through not just and we'll figure out what assets you have, but we'll also sort of give you very particular instructions about this asset should go into the trust, this asset could go into the trust. Here's maybe why we think it should or shouldn't, or things that at least you consider, and then you can make the decision. And then here's some things that we for sure say don't put in the trust, like the vehicles, the qualified accounts, right? Having somebody who's going to identify what accounts you do have and give you specific advice about those particular items, from what I've seen, that's not kind of the norm. You might get kind of a default thing about different types of accounts, and maybe you have to kind of parse through and figure out what applies and what doesn't. But we pride ourselves on giving more particular direction, so that way exactly for the things that I have, how should I handle them. And it also matters too for special needs trusts, right? Because special needs trusts are just like normal trusts. If you choose the wrong funding source, you'd be looking at some real serious income tax consequences. And you really run into issues too. Let's say you choose 401ks, maybe that's going to fund your special needs trust. That's a huge problem because inherently the special needs trust is for these excess expenses above Medicaid. If you're not having enough of those to match the required minimum distributions, then you're sort of in a tension here because you can't force it to make distributions, but you also have to take those distributions. And so you're for sure going to generate income tax, but you're also just putting that trustee in a real bind. And so they'll have to kind of just create things that the money just gets spent on, right? So it's much better to, ideally we say if you can have a particular life insurance policy, and that's going to fund the special needs trust. That's an ideal situation because there's no waiting period in terms of when the money's available for that person's needs. There's no inheritance tax issues with it. There's no income tax issues with it. So you don't even have to mess around with the taxes of it. You just have money available for that person, and it will be able to be used. So the very last issue, and I kind of have been alluding to it already, is about beneficiary designations. So are you missing a beneficiary designation on accounts, or are you naming it improperly? And I kind of alluded to this life insurance versus retirement account, but I'll go a little bit more into it briefly here. So retirement accounts, they're not your most desirable funding source for special needs trusts in particular because of those income tax consequences. Um, and partly it is the difference between immediacy versus um, being able to delay it, but having those taxes associated with it. If you cash out an IRA, a traditional IRA, or a 401k, then you'll have this big chunk of money that's going to be taxable. And if there are a whole bunch of expenses kind of early on for that person, then they're going to lose a pretty good chunk of that amount of money for them. And like I said, if it's a life insurance account or even just a normal bank account, that's it. You're not going to run into those same issues. The other piece too to this is how do we make sure that if it's your money and it's going to be in a third party special needs trust, i.e. your money, um, do we make sure that other people have the ability to inherit this after you pass away? Some attorneys that don't specialize in guardianship and conservatorship don't deal with special needs people or these communities on a regular enough basis, they might not recognize and identify that opportunity, or they might not counsel you in a way where you get to use it to the best of your ability. So, what do I mean by that? Well, there's some real opportunities. Let's say you have a special needs kid, you have other kids maybe around the same age, and you anticipate that um, they're each going to kind of get their shares, and each kid's going to have plenty of money. Um, Maybe you decide, okay, I actually want a charity to inherit after my special needs child passes away. Maybe it's a charity that you have worked with. Maybe that was beneficial to your kid. Um, Sometimes that's just not top of mind for estate planning people that aren't in this world because their default, and really the default for everybody, is um, if that child passes away, it should just go to their children or to whoever else is in the family, right? So maybe to the other siblings if they're living, maybe to your grandchildren if your kids have also passed away. So it's just important to be able to recognize that each person is going to have different desires about how funds are used and who's going to be receiving what and how that's going to be handled. Um, and there's some real opportunity there that I think gets missed from most places. Practically too, I talk about improperly naming beneficiary designations. A lot of people say, what does that even mean? Well, similar to what we talked about earlier, if you didn't fund your trust and the money just went directly to the person, big problem, right? You're risking loss of benefits. You're risking a whole bunch of tax issues. You're risking clawback of funds from Medicaid. All those same issues can reoccur if you don't name your beneficiary designations on accounts properly. And I say properly because there are ways to do this. If you name just the individual's name. So let's say I have a daughter named Eleanor. Let's say Eleanor has special needs, and I name my beneficiary designation on my simple IRA, Eleanor Wasson. Okay, she's going to get those funds. That's true. Now, though, she is all the same things I talked about. She's at risk for loss of benefits, Medicaid clawback. It's going to have to go in a special first party special needs trust and tax consequences. Versus, let's say I have a trust for myself and my wife, and I have a trust share that's going to come out of my trust for her. Instead, you would have different language, something like the special needs trust share created for Eleanor Wasson from the Erik and Erika Wasson Trust. The difference there is now the designation is that it's going directly to that share. That is a special needs trust. And so the IRS, everybody involved is going to say, okay, this is actually going to a special needs trust. It's not going to her. We can put our blinders on and ignore that set of money. and we can totally allow her to continue getting benefits. Um, and the same kind of thing if you have a separate document for your special needs trust. You created it now because you want to start using it now, you want to start funding it now, et cetera. Totally great, totally fine. But again, you just want to make sure that your beneficiary designation, if you're gonna have life insurance, whatever, that's gonna go fund that, that the designation on it says the special needs trust of Eleanor Wasson, or whoever your kid is, right? So just naming it, and it seems like a really simple thing. It seems like it wouldn't matter, do I name it special needs trust or just her name? Who knows? Does it matter? It totally matters. It makes huge difference in how much they're going to get and how much your other children might get or your other beneficiaries might get after they pass. It has a huge impact on eligibility, and it can really, change the outlook of that person's life just by how you name something or whether you name it. And the other thing too to think about too is how do you name beneficiaries on other accounts? Because there's ways that you can do this. You can name the trust, and this is what I would recommend. You can name the trust, and then the trust gets to dictate who gets what and what percentages, sort of auto allocates. So let's say you said, I have 4 kids. I want it to go $100,000 to my special needs trust for my special needs kid, and then a third, a third, a third to my other kids. Well, now if you just name the trust, the accounts will basically auto, you probably have somebody to help do the math, but it'll auto allocate based on your trust provision. And if instead you try to guesstimate and do the math and say, well, I have an account here that has 100K, I have an account here that has 200K, I have a home that's right now worth 350K. I'm going to try to balance these out. So I'll try to do a transfer on death deed that's going to say to my son, Joey, and that's 350K. And now I got to do these other 2 accounts to Susan, right? You're doing guesswork math at that point, because you're trying to like individually pick and choose your beneficiaries to receive certain accounts to make the math add up. You can do that and it might work, but that's just not the best way to do things. If you just have the trust document already, you're able to use it, you're able to let that do the work for you. Let it do the work for you. Let it have all the provisions set out so that you can make sure that people are actually getting even distributions on things the way that you want them to. Or not receiving things the way you want to. Like let's say you did have a child who was not somebody who's been good to your family as an adult now. Maybe they're um, just perpetually incarcerated, committing crimes, whatever, and that money's not going to be a good thing for them. Well, then you want to make sure that they're actually not going to get that money. And if you don't do any estate planning, they will. Or if you don't properly name things, then there's a risk that they are included, right? So there's all kinds of ways that you can do beneficiary designations to make sure your goals are accomplished. It's just remembering to actually follow through on doing them, working with the kinds of people who are going to give you the particular advice about the particular kinds of assets you have, and make sure that what you actually want to happen happens. The last thing too is, and I kind of alluded to this, but let's say you do make these kind of haphazard beneficiary designations, but your trust document says something entirely different. Well, now you're at a conflict place because you have conflict between what the trust says and what's actually happening on the ground. And the hard part is, once the beneficiary designation is made and the money's paid out, almost always that means it's kind of done. Let's say you had a beneficiary designation for a former fiance. That could happen, and now your estate is going to that person, absent something, kind of crazy happening. But that's probably not the person you actually want to receive your items of your estate right now. And so it's good even just to think about that with your estate plan. If you're not looking at it and reviewing it and updating it over time, it will still dictate. And so you may have named somebody from 20 years ago who was a good friend then, and now you have no contact with, and you said, okay, a quarter of my estate's going to go to this person. Well, that's not actually what you want anymore. So why would you let that, um, dictate who's going to get what? And partly I talk about this in the context of beneficiary designations because you can use those beneficiary designations to kind of work around that. But even better than that is you could come to somebody like us, our firm, come to me, come to Molly, come to Phil, come to the attorneys at our office, and we are more than happy to review your documents, or if your documents are in shambles, to just create a new set of documents, a new estate plan that actually gets what you want to have happen, make sure that it actually happens, and make sure that you are properly funding your trust, your special needs trust, um, that benefit eligibility is not going to be lost, that if you have specific questions about how do I actually handle this particular situation for my kid who's special needs or is under guardianship, that we can give you that advice, even sometimes for free in our weekly Zooms, or we can give you different resources. We can connect you to the kinds of folks that you need to be talking to. And so I just really invite, all of you guys, if you have an estate plan, awesome. If you've heard anything in here today that triggers you to say, okay, I need to have somebody else look at this, go through it with me, please reach out and we can do that. Or if you're hearing this and you say, oh, I don't have an estate plan and I have a kid with special needs, and I'm concerned that, if I pass away someday, what's going to happen to them and their funds? Are they going to be at risk of um, not being benefit eligible, or having those funds claimed back by Medicaid when they pass? If any of that has kind of triggered in your mind, I would just really encourage you to reach out. I've put our contact information here, so our general phone number. Feel free to call us, and our wonderful client coordinator, Grace, will be will be an awesome person to talk to help set that up for you guys. I have my email on here as well on our website. And I just want to thank each and every one of you for hanging with me here in the beginning with the tech troubles that we had, but B, just being willing to hear us out, to engage with questions, for the support that you guys give to your special needs children and family members, for the support that you guys provide each other in this kind of really tight knit community that we have, of special needs folks, of folks that have dementia, and just of all of these parents who have guardianships, et cetera. So I'm so grateful for each and every one of you for coming. And I really want to invite you guys to engage with us, whether that's the weekly Zooms, whether that's reaching out about estate planning, special needs trust planning, reviewing that. That invitation is out there for you guys. So once again, thank you so much. I appreciate everybody who attended this. Wish you all the very best of weekends here, and try to enjoy some hopefully not too hot weather, and hopefully a not too rainy weekend. So wish you all the best. Thanks so much for attending.